Welcome. Happy New Year. We're so excited for 2016. We have so many wonderful shows lined up for you. And new for this year, we also have a wonderful new host. I'd like to introduce you to Christina Papavasiliou. Welcome, Christina.
Thank you.
Christina is a criminal defense attorney. She's been in private practice in the city of Chicago for more than a decade. And prior to that, she also worked as an assistant state's attorney. So we're glad to have you.
Thank you.
And Dana, how are you doing?
I'm doing great. Happy to be here. Happy New Year, girls.
Happy
Nice
New
to see
Year.
you.
So tell us what's going on in the world of probate law.
Well, I wanted to talk to you about an issue that is not new news in probate, but it's recent news. And I say that because in the last couple years, there has been a slight change in procedure. And this is regarding a disabled adult who is an elderly person, likely, and wants to make a change to their estate plan, or the guardian of that disabled adult wants to make an estate plan.
Well, I was just going to ask, do they have the capacity, if they're disabled, to make a change?
That's exactly where I'm going with it. It's a question of if someone is adjudicated disabled or is in a lawsuit, I'm sorry, not a lawsuit, but is in a case where their adjudication is pending, can that person make or change an existing estate plan? And the answer is yes, they can, but you have to satisfy several requirements. Right now, if you're in Cook County, you do have to petition the judge in order to get approval for that estate plan to be made or changed. And so that's a change to how procedure was done a couple years ago and earlier. It's a good change, in my opinion, because now there is more oversight and there is criteria that you have to meet in order for this to happen.
What if someone wants to object? Like, let's say I don't think it's a good idea that mom changes her plan, and I think maybe there's some undue influence going on. What would I do?
Well, you could come in as an interested person if you are one of mom's children, or if you are one of mom's siblings. You're certainly someone who has an interest in her well-being. You can come in and voice your opinion to the judge. You can get, if it goes further where you really want to be represented at a hearing on the issues, you can get an attorney to represent your interest. You can compile evidence for your position, present it to the judge, and ultimately the judge is going to look at the situation, consider all the evidence, consider what the impact is on the disabled person's estate. The guardian ad litem is key. They play a key role because the judge relies on them a lot for their report and their findings. And so ultimately, the judge is going to look at the situation and make a decision.
So we're talking about physical disability or any type of disability?
Well, we're talking about disability to the extent that renders a person incapable of making financial and health decisions for themselves.
So then why would it be a good idea to let someone like that change their plan?
Well,
under what circumstances would that actually pass the testing that you're describing before the court?
Well, an example would be, let's say a disabled adult has a legal guardian, and that disabled adult has a net worth that is very high, and their estate could be subject to federal estate taxes should that person pass away. And let's say there are estate planning techniques that can be used to save several sums of money, and that can only be done if there's a change to the estate plan. So that would be an example where the guardian would want to petition the court to make a change to the estate plan, excuse me, or create an estate plan that could effectuate that result for the ward.
So in general, you think this is a good idea?
Well, I really like that there are additional,
safeguards.
Right, yeah. Exactly, a good point. Safeguards is a good way to put it, because before, some of these things were happening without judicial oversight, and they would lead to bigger problems. You may think immediately, if a disabled adult has a change to an estate plan and one of his or her children is written out of the will or the trust, if there was no judicial oversight or a hearing taking place to make sure that that was in fact of the best interests of the ward, then there could have been undue influence, and you're basically ripening the situation for a lawsuit after the disabled person's death.
It does seem that the law is moving toward more oversight. Is that safe to say, just in general?
Well, I definitely think in the probate division and the disabled adults side of the probate court has increasingly added more supervision. And I think it's because all the problems that have been coming up as our population ages, these things have been becoming more common and more frequent.
It's a very vulnerable group if you think
Absolutely.
about the fact that they can't make decisions for themselves and yet have all of these assets.
Absolutely. So
All right.
the takeaway here is that just because someone is a disabled adult with a legal guardian in probate court, that doesn't necessarily mean that they don't have testamentary capacity. But if they don't have it, the guardian still may be able to make an estate plan or change an estate plan with the judicial oversight.
And I love the fact that there's a way for that population to still get their legal needs met. Thanks so much for sharing, Dana. Thanks, everyone. We'll be back in just a minute. Welcome back. I wanted to talk a little bit about guardian ad litems. Dana, I know you just mentioned guardian ad litems in the probate arena.
Right. We actually use them a lot in the disabled adult courts.
And did you guys know that we also have them in family law?
Yes.
So one of the things I wanted to bring up, and this really ties into the fact that it's 2016 and there's a lot of changes in family law that attorneys should be educating their clients on.
I heard about that. There's a whole overhaul, right?
It's pretty exciting. So one of the things that the courts have decided is that rather than split up custody, it used to be pretty contentious, right? Someone has sole custody, someone has joint custody, who's a residential parent? All of that has been thrown out the window now. So instead,
I don't understand how this is going to
let me
work.
explain this to you. Instead, we have two main concepts when it comes to children. Parenting time, which used to be visitation, and parenting responsibility, which is different decision-making skills and capacities. So rather than be so strict and formal, I think the courts want to provide a little bit more room for flexibility and for really paying attention to who is really going to meet the best interests of this child.
Okay.
So that ties into why I wanted to talk about GALs, because a guardian ad litem is appointed by the court to really tell the court what's going on here, right? Who do I believe? Is dad going to be able to get the kids up, get them dressed, get them to school every day? Is mom going to be, better able to handle a special need child who, needs a lot of extra attention and emotional support? A judge is typically not in a position to make those decisions, and that's when a GAL gets appointed.
And so the GAL in family law is who? Is it an attorney?
It's an
Can it be a
attorney.
caseworker?
No, it is an attorney. And there are two roles that people often get confused, but they're not the exact same thing. There's a child's rep, which is an attorney for the child. And then there's a GAL, which is appointed to decide what is in the best interests of the child.
So I thought all this time that the GAL is the child's attorney.
No, because if you are representing an individual, as lawyers, we know that you're going to do what your client asks. So if you are representing a child and he says, I want X, it is your ethical obligation as an attorney to argue for that. However, if your goal is to find out what is in the child's best interest, it may not be what they want. And
That
that's
happens
an
in my
important
house
distinction.
all the time. The child always wants dessert for breakfast. And I always say, no, that's not in your best interest, so your request is denied.
That's a really
Like a
good
GAL.
point.
That's what a GAL would say, I would hope.
So Dana, one of the really fascinating things is this issue of cost, right? Like who pays for this? You brought up
And not only who pays for it, but did you say who the GAL represents?
They represent the best interests of the child. So they are an attorney, but they're not there to represent one individual's interests over another. And that's why it's a really important role, because this is someone the judge can trust to really say what's going on in this family. They interview everyone, they do a home visit, and they write up a report. And they say, this is my recommendation as the GAL. This is what I think is in this child's best interests. And I like the fact that you mentioned it's an attorney because, as we all know, attorneys are not cheap.
Right, so who foots this bill?
That's a really great question, and it's really decided on a case-by-case basis. Judges will look at the capacity of the parents to contribute. Sometimes it's a 50-50 split, sometimes it's an 80, 20. It really just depends on what resources are available. I've worked with families that say, we don't have the resources at all, and sometimes judge will appoint someone from the public guardian's office, but very rarely.
Okay, so like a volunteer GAL.
Correct.
And
but you have to qualify for that.
okay, and in all cases where there's a minor, or is there a GAL appointed, or is...
No. So it doesn't have to be appointed if the parties can reasonably figure this out for themselves. But as we all know, in divorce law, there tends to be a lot of conflict, a lot of fighting.
Especially when kids are involved.
Especially when
Right.
kids are involved. Now, we're hoping that with the new laws, hopefully people will feel like it doesn't have to be so contentious. It's not like one person wins and the other person loses. We want to look at it as more, what arrangement can we come up with now in our new family that's going to be in two separate households? How do we do this?
So is this only involving custody or any matter that may arise in a divorce?
That's a really good point. So it really pertains to what is in the best interest of the child. And that's typically around issues in terms of custody, well, what used to be custody, in terms of parenting time and
Parenting
parenting
time.
responsibility.
These buzzwords, we'll have to get used to
I
them.
know.
Everyone knows custody. You don't have to be a lawyer. Everybody says custody.
Right.
It's like the Sears Tower.
Right.
Oh, I mean the Willis
That
Tower.
was a while ago. I
Are we
have a
even
hard
allowed to
time.
say
I
Sears
know,
Tower?
I
have a
still
hard
say
time.
I don't.
Yeah.
This habit was formed over a
Oh,
long
yeah.
period of time.
So ladies, we'll have to see, how this goes in family law court, but we're hoping that this is a change for the better, and maybe GALs won't be needed quite as much because they are expensive, and for families that are already experiencing a lot of financial strain, I think it's best for everyone if we can figure it out without having to appoint
Yeah,
another
I have a real
attorney.
quick question. Do either of the parties have anything to say about which GAL gets appointed?
The attorneys for the parties can put forth a name that they've heard of, and the judge can weigh in as well. The judge can appoint their own GAL or ask the attorneys to figure it out and pick someone that they both agree on.
Okay. Well, I'm looking
Wonderful.
forward to hearing about all the new changes in family law going
Yes.
forward.
Yes, wonderful
Exciting.
talking to you guys, and we'll be right back. Welcome back. We're so happy to have you joining us. And Dana, new for 2016, tell us what we can expect in this wonderful land of law.
Well, as you know, every year we have a bunch of laws that go into effect January 1st. There are some that have been needed, for a long time, and there are some that are a little bit unusual, and then there are some that people are not too happy to hear about. So I picked several that I thought would be interesting for us and our viewers to know, and I thought I'd share them with you. One of the changes that went into effect January 1st is that if you now exhibit cruelty to animals in front of a child, that's the difference, because we did have a law preventing cruelty to animals that was punishable by fine, but if you do it in front of a child, you now are exposed to a higher fine. There's a higher criminal penalty
It's really interesting.
for that. Yes. Cruel treatment of animals, violation upon a pet in the presence of a child shall be subject to a fine of $250 and ordered to perform community service for no less than 100 hours. So that's good.
Significant.
Yeah, I think that's important, showing how to properly respect other living beings, goes a long way in our next generation and how they should behave.
Yeah.
Another law is that we are now allowed to hunt bobcats.
Really?
Oh, wow.
So all of
Boy.
you that have been waiting for this day, it's finally arrived.
Not just off the roof of your house, right?
Right. So,
Didn't you just get done talking about cruelty to animals?
in 1972, apparently, bobcat hunting was banned, and we must have had quite a population growth spurt in the last 35 years. So you will now be able to hunt bobcats in Illinois between November 1st and February 15th.
In
What a
designated hunting
season.
areas, I hope, right?
I hope. Let me see. Another great law is that carbon monoxide detectors, they were required in your residence a few years back. I don't remember the year, but a few years back you're required to have a carbon monoxide detector in addition to a smoke detector. Well, now, effective January 1st, all schools are required to have carbon monoxide
Well, that's certainly good.
detectors.
Yeah, that makes sense.
Yeah, exactly.
Why not? They're very inexpensive too.
Yeah.
We have another change to school law is that we have a little curb in the tolerance required by school officials and administrators.
What do you mean by that?
Well, it used to be a zero tolerance policy was encouraged and implemented through the schools, but we are no longer allowed to do that. Administrators will be required to try every option that they can and impose new policies which prevent expelling a student before imposing out-of-school suspension.
Wow, so giving the kid a few chances.
Yeah,
basically,
that's
is
where
what
we're
you're
going with
talking
it.
about.
Interesting.
I think that makes a lot of sense.
For any, I mean, regardless of the offense.
Right. Right now, they are allowed to have a zero tolerance policy, and they are loosening.
Yeah.
The legislature has loosened that a little bit and is forcing school administrators to change their policies to make it a little softer,
Right,
I guess, is
right,
a way
like
to put
three
it.
strikes.
But, you know,
you're
we're dealing
out.
with kids here, so that makes a lot of sense to
Yeah.
me. You know, their executive functioning is really poor at that age, and they just don't have the abilities that we do as adults to really worry about consequences.
You know, I'm a little worried about this one myself. I think that sometimes harsh consequences serve as an example.
Not only as an example, but also as a learning experience. I mean, I think of the things I learned my greatest lessons in life from, and they were the hardest times.
Well,
They were-
yes, but if zero
That's-
tolerance, you're going to be at home. You're not going to be learning much of anything anymore. How are you going to graduate from high school?
Yeah, I'm not sure that I really like taking away all zero tolerance policies, but I think I would be more comfortable with something that certain offenses you can still keep a zero tolerance policy, and others you can implement, you know, 1, 2, 3 strikes or other
Well, it's
other
complicated,
procedures.
right? Because there's something like drugs, zero tolerance. I mean, that's not really providing a learning experience. But on the other hand, if you're keeping other kids safe, such as zero tolerance for violence, well, you know,
Right.
that's protecting other children.
Right.
School administrators do have a tough task on their hands.
They do.
So it'll be interesting to see how that plays out, and if any changes that come from that, you know, improve the
So,
situation.
is there a timeline to do this?
No, not that I saw. Yeah.
Where can we learn more about these new laws? How do we find out what's going on in Illinois this year?
Well, there are a lot of articles that newspapers or magazines will put together a list of common laws you should be aware of. Or you can always go, of course, to the Illinois government webpage, which also will, you know, point you to the new laws. There's one more that I want you guys to know
Okay, Dana,
about.
but we only have just a minute, so spit it out.
Okay,
Make it worthwhile.
there's three more that I want you to know about.
Pick your favorite, Dana. Come on.
Traffic ticket fines are being raised by $5.
Oh.
Oh, but to end on a happy note, airports that have more than 1 million enplanements are now required to provide a secure screening area for mothers who want to breastfeed.
Oh, well,
Oh,
isn't
that's
that
nice.
nice? Very interesting. Thank you so much for sharing. I'm sure our viewers have learned a lot, and we'll be back in just a minute. Welcome back, everyone. We're so glad to have Christina with us because she's going to talk to us about a new area of law that we haven't discussed on this show before. I believe you're going to educate us on DNA evidence. Is that right?
Yes. My background is in criminal law, and these days DNA evidence is really considered the most solid evidence that you can have in a criminal proceeding.
Aren't there like 20 CSI shows about this very topic?
Yes, and people are fascinated. I mean, juries are fascinated by DNA evidence. They tend to give a lot of weight
Is
to it.
DNA evidence conclusive? I mean, if you have a DNA match, is that?
Don't do it while she's talking. When Smiles is talking, then you got to go in. Because you're doing all the
Technical.
You're doing good,
Great.
but we're gonna have to redo it.
Now we have to restart. That was fun. I'll have to remember the jokes.
Yeah, do it exactly the same
I
way.
know, right?
If you can.
I'm sure I can.
Yeah, so Sam, so again, we see your camera drag.
Okay.
Funny.
Let's start that again. 5, 4, 3, 2, 1.
Welcome back. We're so excited to have Christina here with us because she is going to talk about DNA evidence. And I don't think we've talked about that yet on this show.
I don't think so.
My background is in criminal defense law, and DNA evidence is the most solid type of evidence. It's given a lot of weight by judges and especially by juries.
People love it, don't they? I mean, isn't that why there's all these CSI shows that are so popular these days?
Yes, juries love it. And it holds your attention, it's fascinating, and the only problem with it is that sometimes it's given a little bit too much weight.
Well, is DNA evidence conclusive? I mean, if you have a DNA match, is that 100%, you know, it is what it is?
So, well, it can be. Basically, good DNA science is very reliable. But the problem is whether the sample is good, and whether it's good science or what is being known in the criminal law community as junk science.
Wow.
So wait a
Junk
minute, how
science.
can a DNA match be a bad sample?
So basically, if the way that it's collected, there are strict controls over that. Obviously, there's chain of custody. So all evidence in a criminal case has to.
Okay, so let me slow down here. Chain of custody means what's happened to the sample, right?
Yes. Where has it been? Where in the lab has
Who's
it
touched it?
What else exactly? What are the protocols in the lab, and were they adhered to? There has been a
So
lot.
can DNA change?
Well, it can be contaminated.
It can be contaminated. That changes the DNA reading. Like when I see a strand of hair fall on the ground, I think there goes my DNA.
Yes, and that's a fact.
I think of that every time. And I think
You're obviously a lawyer.
if there's a crime committed here and they collect my hair strand, are they going to call me?
Well, I don't think they'll call you. It's unlikely that your DNA right now is in the criminal database. So,
You have to be a criminal to have your DNA in there?
well, it has to be matched to you somehow. As of 2016, all of our DNA is not in some vault where they can just run it and find any
So
one of
really,
us.
it's
Not
best
yet.
if you're dealing with someone who's been accused of a crime before, right? Because then maybe a sample has been
Yeah,
collected.
Yeah. And it's very controversial. There are privacy issues with that too. For example, in England, there are higher protections. Here, basically, once you're in the criminal law database, you're in there forever, and how you got there is insignificant. So let's say I'm accused of a crime and I'm acquitted, but my DNA is in there. It stays in there.
No, I think that's fine. I don't have a problem
you
with
think we should
that.
have some national database of
Well,
everyone's DNA?
Yeah.
I don't think so.
I do.
That's a little overreaching for me.
Why?
Me too.
Why
What's-
should the government know? They
What's
don't
the
have to-
harm of your
Oh,
DNA?
please. Because listen to what she's saying, chain of custody. What if someone took my DNA and we don't know what they did with it, and all of a sudden there's a match? And I mean, next thing you know, everyone's going to say, oh, 99% conclusive. And
Well-
I might have be completely innocent. Doesn't that ever happen?
There have been some very scary cases all over the United States in the last 20 years of mishandling of evidence. I mean, one thing about these labs is that they are part of the prosecution's effort, and they are employed. They are basically, typically, they receive information. They have to verify what the police has provided to them. And there are some scary stories of.
Now, I'm not quite sure when you say contaminated DNA, does that mean that the DNA is not readable, or it's not like if you have DNA, it's some sort of code.
Right. Mm-hmm.
And so for it not to be reliable, is it like saying one of the numbers is missing?
Well, DNA is never going to come back unreliable. That's the problem. I mean, yes, sometimes it's like a bad sample, and it's supposed to come back. This sample is contaminated, and somehow, or there was a break in the chain of custody. The scientist is supposed to report what occurred and whether it fit all of the criteria in order to be considered.
But to
a good
answer Dana's
sample.
question, I think contaminated is if Christina touches this chair and her DNA is on that chair, and I come and I put my fingerprint on it, and let's just say, somehow my DNA gets on the chair, then when they come and take a sample, it could have both of our DNA on it, whereas it's not supposed to, right? Is that what we're talking
Well,
about?
yeah, that's less common though, because let's say that they find the detective's DNA, well, that's easy enough to exclude. right?
True, because we all know why the detective was
So
there
you
and
can
when.
separate out,
Yeah.
if all these DNAs are having a party, and you can then separate out everybody who's there by their DNA.
Yes.
Well, I'm not getting
Well,
the
if you-
contaminated
But
part.
that is contaminated, because what if there's only one criminal? I mean,
This is a
guys,
fascinating-
We're gonna have to talk about
This is a
Yes.
fascinating
Another
subject.
time.
We could do an entire show just on this.
But thanks, Christina. I've learned so much, and I'm sure our viewers have too. We'll be right back. So I'd be really surprised if our viewers have not heard about the Bill Cosby case going on.
Is that
in
our
the
hot
news.
topic?
It is.
Yeah,
So
I don't blame you.
I really want to hear what you guys think about this, because one of the questions is, do you think he's able to get a fair trial? I mean, who hasn't heard about this?
Right, where is he going to go?
Right.
Yeah, no.
No.
I mean, on one hand, I don't think he can go somewhere in the country that
Where
no
no
one
one-
is going to know
Right.
about
Have you
it.
been hiding under a rock
But-
for the last 12 months?
Right,
Right.
but that said, I don't know that a change of venue is going to give
Right.
him any advantage in that way, so he can go anywhere as a result, is what I mean.
Well, we've all heard about being tried by the court of public opinion. I mean, do you guys think that's what's happening here? Do you think that the evidence is really going to matter, or do you think everyone's already made up their minds?
Well, I think you always hear these celebrity stories, and you get a lot of news bits, and so a lot of people do, put 1 and 2 together to come
But
up with
sometimes they
3.
put 1 and 2 together incorrectly.
And-
They're
and I
bringing
think-
that prejudice to the courtroom.
Yeah, I get that, and I think that that's why the jurors are going to be charged with really paying attention to evidence in court. But I think that's what jurors do. I think the jurors do try their best because they realize the consequences.
But what about the fact that he is a celebrity? I mean, don't you think sometimes people have a hard time thinking about the actor that they loved and that they admire so much actually being able to commit a crime?
Well, I think that
Yes.
some people would say they would be more frustrated and angry that someone that they loved kind of betrayed their own sense of integrity by doing such a crime, that it makes that person more angry.
But they'd have to believe that it was committed.
Yeah, you're right.
But a lot of people believe that, I mean, what I keep hearing with everyone that I've been talking to is that the consensus is so many allegations basically create this presumption of
Yeah, but
guilt.
Christina, you're a criminal defense attorney. None of those other pieces of evidence should come into this particular case.
I'm a criminal defense attorney, and I'm aware of how juries think. I mean,
But shouldn't that be excluded? Because we're not
Well-
talking about any of those other women right now.
That's likely to come up. So basically, there's something called other crimes. It's the doctrine of other crimes.
But don't you have to have committed those crimes? Don't you have to actually have gone through a court of law before
No.
those allegations stick?
A conviction isn't required. Basically, if there is evidence, and testimony is evidence, if there is evidence of other crimes, and it's not offered only to show, okay, this person committed the crime before. If it has other relevance, such as modus operandi, then it can be admitted.
Okay, wait,
Wait,
that was
whoa,
legalese.
modus
Back it up.
operandi.
What is that?
It basically is the way that this person operates.
Oh,
right?
like your mode of operation.
mode of operation.
Your MO.
Exactly.
I got
yes,
that.
MO.
Okay. Well, guys, what do you think about the fact that, based on what I've read, the evidence is clear that if you look at the statute in Pennsylvania, which is where this case is being tried, that based on the definition, he doesn't even dispute the charges. The issue is, did she or did she not consent? And Bill Cosby, in my understanding, has said that she didn't really say yes, but she didn't really say no either.
Is DNA involved in this case?
You know, I don't think it's relevant because he's alleging that she did consent. So even if the DNA is there,
Okay.
I mean, obviously
No
it
one's
would work.
disputing the facts,
Okay.
right? Which is
'Cause
that
I wanted-
he used a part of his body to penetrate her. And that's been clear. And the fact that there was some intoxicant involved, I think has also been established.
Okay, and so I was just wondering, in going back to your question, whether there was proof, or do both parties agree that there were
the
drugs
incident
used.
happened. Well,
Both parties agree that basically he touched her in the way that she alleges. Not against her consent, but that there was touching.
What about the drugs?
well, she
Well-
says that she was given Benadryl and wine, and there could be other substances, but we're not quite sure what they are. Now, my understanding is that he has not admitted to providing her with anything that could interfere with her ability to consent. However, as Christina mentioned in prior testimony, he has mentioned that he has used drugs to render women, how do we put it, more amenable to his advances.
To help them relax.
Correct.
And that testimony was related to,
A prior incident, to my knowledge, which happened years ago, and it was settled out of court. So nothing ever
Uh-huh.
came of it, but this testimony was available and it was sealed until very recently.
and this then comes back into this case as part of the doctrine of other crimes?
Well,
because
if
it's
they
testimony?
succeed in showing that it's relevant, and I think they will because of the mode of operation. I mean, it can't be like, oh, he's a bad guy because somebody else complained about this before. It has to have its own relevance, independent, either self-verifying detail, which is just some detail, like let's say she saw something in the house that was only there for one day, for example, so it proves that she was there that day. If that was in dispute, you know what I mean? Something else besides just, he's a bad person, that can't be what you're trying to prove. You have to be proving something else.
So what do you think the chances are? Do you guys think he's gonna walk?
It's so hard to say. The problem in this case is the amount of time that
Yeah,
has
it's
gone
been
by.
a while, hasn't it?
It is really tough, and I've seen this before so many times in criminal cases. When people don't report right away,
But she did, though. She reported it to the police, and my understanding is they decided not to bring charges at that time. But at
Yeah.
least her testimony is there,
Yeah.
right?
Well, right. So the reason that this case is able to be prosecuted is because in Pennsylvania there's a 12-year statute, and so there are about 29 complainants right now of sexual assault, and something like 50, in the 50s, of just general sexual misconduct. And the reason that none of those other cases can be brought is because of these long statutes
Wow.
of limitations. If the police, if either the victim doesn't report or the police don't prosecute, it's so tough to prove a case.
We'll see what happens. I know
Yeah.
everyone's probably going to be sitting on the edge of their chair.
Yeah, I'm not sure what I think will happen.
I mean, we want justice to be served, right? And let's hope
Yeah,
that
we do.
let's
Yeah.
hope that whatever happens, everyone will recognize that it's a fair trial, because I think sometimes we've had problems with that when it comes to celebrities. There's been allegations that, things just weren't done the right way.
Right.
So stay tuned, everyone. Thanks for joining us. Have a great night. Thank you so much for joining us. If you have any comments, any questions, please reach out. We'd love to hear from you. You can reach us on Twitter. You can leave a message on our Facebook page. We're so happy to have you visit our website as well. We look forward to hearing from you. Have a great night.
Hi, welcome to Bar Talk. Pull up a seat. We have a great show for you today. We're going to be talking about holiday time with children of divorced families. We are also going to talk about personal liability exposure for fiduciaries, and we're going to touch upon credibility during trial. So let's start with Ish. I want to hear about holiday time for children in divorced families.
Well, what really got me thinking about this is in the news recently, I've seen a story about Madonna. As some of you might know, she has a child that she is raising with her former husband, Mr. Guy Ritchie, and Mr. Ritchie is based in London. And
Does she have
Madonna-
one child with him or two? I'm sorry to interrupt.
She has one
Biological.
child, and they also adopted a son together.
Okay.
But we're talking about the older son, who is a teenager. And the issue in this case is that the judge had ordered, as a result of the divorce, that this son would be raised by Madonna in New York.
Okay.
However, now that he's a teenager, he's kind of going through a little rough spot with his mom. So it is reported. Of course, I don't know them personally.
Sure.
But just based on what I've read, it sounds like he doesn't want to live with his mom anymore. And so the story goes that she was on tour, and when they landed in London, he kind of jumped ship. He's like, I want to go live with Dad. And so he took off, and he went to live with his father, and Madonna can't get her son back.
Oh, now he wants to live with his dad on an ongoing basis?
Permanently.
Or this just happened during the holidays, but
Well,
it's not really
this
about...
happened during the holidays, and that's what was so interesting about it, is because Madonna actually went into court and sought an order ordering the child to be returned to her in New York. And everyone thought she wanted him home for Christmas, right? And everyone got nice warm fuzzies about it. But the real issue is, can a child decide on his own who he wants to live with without court intervention once you are under the jurisdiction of the court because of a divorce action? And the answer to that is no, it's not his choice. And in this matter, the judge actually ordered that he be returned to New York prior to school starting in early January.
So is that enforceable? Is that enforceable in another country?
That's a really good point. And so what the court also ruled, this is in New York, the Supreme Court in Manhattan, they ruled that New York has jurisdiction over this divorce, over the children of this divorce, and over the parenting time and parenting arrangements. And so they believe that London and whatever Mr. Ritchie is going to try to do by hiring his own attorney should not be able to control what happens to the child.
It probably is going to fall under some sort of treaty, you know, that the countries have about recognizing each other's laws. The same thing with
But
like
a London
extradition.
judge, I mean, hypothetically, a London judge could rule something different.
Well, they could, but I
Yeah,
think
but if
what's-
they're tied to a treaty saying, you know, if we have jurisdiction over this matter, then you have to recognize,
The ruling.
right.
So it would have to be, it would have to basically take into account the ruling as though it's law.
I imagine that's what it would
Correct.
do.
But I think this story highlights a couple of interesting issues in family law. One is, who gets the kids for the holidays, right? Because assuming that the child wanted to be with his mother, well, then he couldn't be with his father at the same time. And inevitably, this is a problem with these families. In this case, we have the Atlantic Ocean between the two
Yeah.
homes. But even if you're just in separate states, I've seen some crazy plans where, you know, Christmas Eve, you're with dad, and then the next morning you got to drive 12 hours to be with mom.
All the time.
I mean, it can be really
And
complicated.
it usually is that way. It's usually driving, you know, Christmas Eve with one, Christmas Day with the other. That's
It
usually-
doesn't sound very relaxing to me.
Yeah.
And a question I have about when you said, you know, even though he's a teenager, his input doesn't matter.
I wouldn't say it doesn't matter, but it doesn't control.
Okay, it doesn't
so
control.
Usually at this age, a judge would listen to what his preference is, and my understanding is that it was reported to the judge in this case that the child no longer wants to live with his mother, he wants to live with his father. So this has been set for hearing, and the judge will probably listen to what the child wants, but that won't be how the decision is made.
And is that the same in all states? It goes that way, or is there a certain age in some states? Do you know?
To my understanding, I'm only
Or at
licensed
least
to
in
practice
Illinois.
in Illinois. So in Illinois, I know that there is no age. You are a child. You are a minor. You do not have the right to decide who you're going to live with. If you're lucky, or let's just say in the best case scenario, they will take your opinion into consideration.
Even a 17-year-old.
Even at 17, the judge does
Wow.
not have to follow your request. That's all it is. It's a request. If that kid wants to stay out all night, does he get to do that under
Right.
the law? No.
Yeah.
You're just a child. You have no such say.
But how much weight is it given in reality?
It's going to be given a lot of weight because we want what's in the child's best interest. So if you have an antagonistic child who's really frustrated with one parent and really prefers the other, the courts are going to look into that. But we all know that there's something called parental alienation. Like, what if one parent is making the other parent look bad, and that's why the kid doesn't want to go there? Well, that's not fair, and the courts don't want to support that. It gets very complicated.
Do you have a suggestion for the holiday time breakdown? What do you think?
I would say let's try to make it as peaceful and relaxing as possible. And we all know that that's hard, divorced family or not.
Right.
But that should be the
Yeah.
ultimate goal.
Yeah, have seen families switch off year to year. You know, all the holidays at dad's, all the holidays at mom's. The
Which
next
is what you
year.
have to
Yeah.
do when there's a long distance. You can't do Christmas Eve. You can't do Christmas Eve in London and Christmas Day in America. That's not
Right.
going to happen.
It's just not going to happen. But a lot of people feel very emotionally attached to certain holidays.
Right.
And when I work with families, I always say, pick your top two, right? You're not going to get all the holidays you used to have with your kids. So maybe Halloween is really important to you. You want to do that trick-or-treating. You want to take the pictures when they're in the costumes. And maybe your spouse doesn't care as much.
It's hard.
So
You know, Serbian Christmas is on January 7th.
Yes, that's right.
So if you become Serbian, you can just.
You can have your own
I
Christmas.
think that's in my future.
Well-
That's a great way to handle it. When no one else is celebrating, there wouldn't be quite as much conflict, right?
Right.
Right.
Well, anyway, thanks for that information because it's relevant in a lot of families and, it's something to think about.
I think the important takeaway is this. Your child's opinion does matter, but it's not controlling. But let's try to have an environment where parents aren't pitting one parent against the other, where we're fostering the growth and development of the relationship of both parents and trying to share parenting time as equally and as viably as possible.
Right. Thanks,
Can't
Ish.
argue with that.
Thanks for joining us. We'll be right back after a quick break. And thanks for joining us. If you're just joining us, we're going to be talking about personal liability for fiduciaries, and I'm going to ask what your thoughts are on this issue. So a fiduciary, as you know, is someone that's in a position that to take care of another person. It could be in the role of their health. It could be in the role of their financial assets. You're acting in control over property or care of another, and then you have a legal duty to that person. So fiduciaries take on many different roles. It can be as an administrator in a probate estate. It could be as an agent under a power of attorney. It could be as a custodian of a bank account for a minor. The word fiduciary applies to so many different situations.
Or any bank account and trust, right?
Yeah, I mean, these are all fiduciaries. And fiduciaries have, I think we use fiduciaries frequently in our lives, but I don't think it's always so well known that they have serious legal responsibilities, to the person.
So tell me what those are. Like, what kind of weight does it carry if you have the role of a fiduciary?
The number one thing that I see is fiduciaries often don't think it's a very big deal to mix assets, to what is typically called commingling assets. So the assets of the person that you are responsible for and your own assets, maybe you combine them in the same bank account. Maybe you use some of your mother's money, but you're going to pay it back, and that's the way things have been going on for so many years. Well, if you are in a formal fiduciary role, that could lead to some serious problems.
But wouldn't the argument be who would ever know?
Well, I mean, that bank robbers say that too.
But isn't it true that a lot of these, like let's say an administrator of an estate who it happens to be the child of the deceased.
Okay.
Don't they often not even know that they actually are supposed to keep those funds separate?
Well, they should know because they are usually represented by an attorney, at least, and I am always referring to Cook County because that is where I practice, and I know that some of the collar counties may operate a little bit differently, but still obviously under the law. Well, in Cook County, the judges are not going to administer a probate estate unless you're represented by an attorney. In some of the smaller counties, it may be different. You may be able to administer without representation, but at least here, with the volume that Cook County does and the expectations, judges want to see you represented by counsel so that they make sure you do everything you're supposed to under the law and they can get this administration going.
So would you
and
say
an attorney is going to, it's their duty to then advise you,
okay.
Of everything you need to do, what you shouldn't be doing, what your duties are to others. And
they generally do in your experience.
absolutely. I mean, that is your job,
Yeah.
if you're representing an administrator in an estate. Not
But
only
I like your example before about what if it's a child, you've always commingled funds with your mother's account.
Yeah,
I mean,
because-
isn't there a different standard if it's all in the family?
Well, the fiduciary that you're talking about is very structured inside of a probate administration, but the fiduciary that you're talking about is something that's so typical, the child acting for the parent by being on their account or handling their money, or sometimes that's done casually and sometimes that's done using a power of attorney. Those are all fiduciary roles too, and in those cases they may not be represented by an attorney, so they may not know that they have these duties not to commingle and they have to keep these funds for the person that they belong to, because down the road you may be exposed to personal liability for your actions, and this is where it can get a little bit messy.
Like from the other siblings, for example.
From the other
anyone
siblings,
who
for
has an
example, or exactly, or anybody that has an interest. Maybe there was an heir, maybe mom passes away years later and there is an interested person who's not a sibling. Maybe there's an heir who then gets involved and realizes that there was some mismanagement of mom's estate.
What about someone who is owed a debt?
A creditor?
A creditor, right. Would that person have an interest in basically
Well,
bringing a lawsuit? I mean, is that
They,
ever, does
they
that ever
would
happen?
usually have an interest only to the extent that their debt could not be repaid
Right.
because of someone else's mismanagement. And you might see this in the case of a guardianship estate. So you already have a disabled adult guardianship estate in the courts for a period of time, and then that guardian takes actions as the fiduciary guardian with the estate assets. And let's say the ward passes away and there are creditors who then cannot be paid and there was some mismanagement. You can see how a creditor would have an interest in saying, wait a minute, the guardian used this money in a way that was improper.
And I want it back.
And I want it back. And, you know, it could be the case that the fiduciary has personal liability. A judge could order a fiduciary to repay money that is owed back to the
Really
estate.
good to know.
Yeah,
We have
so-
to keep this
Yeah.
in mind.
So it can get complicated, and I just wanted to really bring up the fact that there can be personal exposure if you're acting as a fiduciary.
Thanks, Dana.
No
Thank
problem.
you.
So thanks for joining us for this segment. We'll be right back after a short break. Welcome back. We are going to talk about credibility in a trial when you're on the stand, and Christina is going to tell us more about that.
So basically, credibility is an issue when you have a he said, she said. So this can come up in so many types of trials, civil and criminal. This actually applies to civil as much as a criminal case. Now, sometimes you have more concrete forms of evidence, but there are times when an entire trial will just be one testimony, which says the complete opposite, which basically provides a case for a completely opposite occurrence than another testimony.
Wow.
Like
so
he said and she
yeah,
said.
So how does the jury figure this
Because,
out?
right, wait a minute. I have a quick question. Don't people lie all the time on stage? I mean, on stand?
You know, I would like to think not, but in my experience, yes, people lie all the time.
Okay, so this is where you're talking about a he said, she said situation. Because
Yeah.
you've got someone who's lying, and they're
One of
both
them is
under oath,
definitely lying.
and they're both,
Because they were both there. One of them is lying.
Isn't this when you bring in like character witnesses and stuff?
Well, I mean, you can, but what if the person, it is possible, isn't it, that the person who's lying is someone who, you know, is not necessarily the most, or it might be more upstanding, you know. So
so they don't
actually-
have a bad character.
Right.
And is that allowed? Bringing in?
It's problematic. No,
Oh,
you can't bring. I mean, you can't bring in a character witness. As you open the door basically to a lot of attacks, and on the other hand, it has to basically pass a hurdle of relevance.
So the idea is if you have a witness that you think is lying, you have to discredit them on the stand.
Right. So there's something called improper impeachment. It has to be very relevant. It has to be pertinent to the matter at hand. So I can't come take the stand and say, you know, Dana lied about something completely irrelevant the other week, so therefore you shouldn't trust her
But
testimony.
we don't know if you're lying about this matter because we haven't been through trial yet.
It's the most unpredictable type of trial. And it's especially problematic when a jury has to decide beyond a reasonable doubt that someone's guilty. There are some people who tell really, really good lies. So let's just take the most basic example, who threw the first punch in an assault. So, you know, the person who calls the police is not necessarily the person who didn't throw the
That's
first
right. I see this in a lot of domestic violence situations
Yes.
where there's an altercation and everyone has a different story about who started it.
Exactly.
But it
And who
really
started it-
matters who the perpetrator is versus the victim. And sometimes the
Exactly.
police don't know.
Exactly. And what if you have someone, now basically, judges and juries alike, they're the fact finders. So they have to listen to the testimony and they have to choose.
Okay, but you're telling me I can't bring in people to vouch for me. I can't talk about something that happened last year that would tell you. So how do we figure this out?
Well, a good lawyer, there are things, a good lawyer can usually A lie can unravel in cross-examination.
So
Aha.
cross, that's
Aha.
the key.
The cross-examination is the key.
You,
It's the secret
you lead
weapon.
them down the path, and then you box them in.
Yes, exactly. Now, in a best case scenario, that's what you do, right? But sometimes it doesn't happen
Are you trying to tell me that sometimes the truth is not revealed?
in court.
Oh, come on. Don't we have a criminal justice system that we can all believe in?
Does deposition testimony that is taken in advance of the trial come back into trial to help discredit?
It can, yeah, it can.
So you've got somebody on there that's saying something that is different from what they said in deposition.
Right, yeah. I mean, prior consistency, there's some rules regarding how to impeach using prior testimony, but
Okay.
yeah, but it can be done. And it's important evidence, so it can come in.
Really fascinating. I mean, this is the stuff that TV dramas are made of, right?
Yeah. Well, it sounds like a issue that is difficult to deal with.
It really is. It's the most unpredictable type of trial.
Thanks for those points. We'll be right back. Welcome back. We are going to talk about wrongful death lawsuits. We've certainly had a lot of questionable things happening in Chicago lately. Wrongful death suits have been filed, so we're going to explore that a little bit as our hot topic. So ladies, recently another wrongful death lawsuit has been filed against the city. Have you heard about this? Having to do with the shooting of a young man. What do you think about that? What do you think about all these recent news pieces about wrongful deaths in the city? And
Well, I guess one question I have is it easy to sue the city of Chicago or even a police department? I mean, isn't there some kind of protection that we afford them so that they have some kind of immunity while they're trying to do their jobs?
They do. They have qualified immunity, and it's a high hurdle. Now, I think that the police shooting cases, in a lot of those cases, that hurdle will be met because you have to know basically what.
wait,
Go ahead.
it's a high hurdle to do what?
To basically show, so qualified immunity raises the degree of difficulty in succeeding in these cases.
Okay, so it's hard to sue the city unless you can
yeah.
jump this hurdle
Right.
of qualified
But
immunity.
you're saying that in some of these cases you think that they can
Right.
meet that burden.
I think they can meet their burden because the burden is basically to show that the officer knew what he was doing was wrong, or she. And
So how would they show that the
Well,
officer?
let's say someone was unarmed and it's been proven they were unarmed and the officer shot them anyway, even though there wasn't a real threat.
Okay.
And that seemed to suggest that that was an act of negligence and that I can sue as a mother or as a sister or as a son or daughter. Isn't that correct?
That's
Because I've been
correct.
wrong. Someone has been taken from me.
Well, let's take the Laquan McDonald case where he was shot so many times.
Right.
So just to parse out this topic that we're talking about right now, if he was shot the first time properly, I don't know, but let's
Right.
say he was shot the first
Let's say that the
time
first shot was
because
justified.
yeah, it was justified.
Yes.
That the officer thought he had a weapon. You know, I really have not looked that far into the case, but for purposes of this discussion, I know that he was shot so many more times, and then that's where I'm applying to this qualified immunity question. If he had justification for the first shot, but he didn't for another dozen shots,
Right.
does that overcome the hurdle of qualified
It
immunity?
does. It
Okay,
does.
so it doesn't even have to be the case that, you know, there is no defense that at first the officer did not.
Right. In fact, under the doctrine of qualified immunity, an officer is allowed to make a mistake. It's when he should have known better, and that's a high hurdle.
Okay.
Because it is also taken into account, and a lot of the cases say this verbatim, that they have to act quickly. They have to act quickly in a high-pressure situation, in a dangerous, life-threatening situation, and that's taken into account as well.
Right. So we understand that they're probably going to make a few mistakes, and we as a society have agreed that we're willing to live with that.
Exactly. And one shot that does happen to kill is very unlikely to be something actionable. But if it is 16 shots, then it's harder to show, okay, he believed he was acting within the confines of the law.
So what about these settlements that we hear? Because sometimes we hear that families have settled with the city. Do you think that there was a wrongful death lawsuit that initiated those discussions, or can the city just kind of throw money at people even without going to court?
No, I don't think you would typically get an offer. I mean, yeah, you don't have to go to court to engage in settlement negotiations, but I think that when the city does provide a settlement, it's usually because they do anticipate a lawsuit.
And they feel they might lose.
And so a wrongful death lawsuit is brought by who?
Any beneficiary and anybody who has an interest, or I mean, you can do loss of consortium, but typically it really is.
So it's a relative?
Yeah, typically it's a relative.
Okay, but it's not just a beneficiary of an estate plan. It has to be a relative.
Typically it's a relative.
Because you have to show that this is a loss for you.
Right, exactly.
Okay. Well, I know we could talk a lot more about this because it's kind of a confusing area, wrongful death, who can bring it, how it happens, and then when you sue the city, the city has all sorts of defenses that it can use. But we're out of time for today. So thanks for joining us tonight. I hope you enjoyed the show. You can always reach out to us on our Facebook page if you have any questions, comments, or suggestions. And we also have a website that we'd love to hear from you on. Have a good night. See you next time.